Hi everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. We're in week 12 and considering workplace health and safety. The textbook reading for this week is chapter 15 in Stewart's Guide, and if you do want to read a little further, have a look at Creighton and Stewart's Labour Law, also at chapter 15. Once again, the discussion about this material takes up this issue of jurisdiction. Why is the Commonwealth not in charge? The situation at the moment is that workplace health and safety laws are principally still dealt with by the states, and the workplace laws are, whilst they're in the process of being harmonised, are still enacted on a state-to-state basis. So although there is an argument that the Commonwealth could use its constitutional powers over corporations to take control of much of this area, instead the Commonwealth has decided to take a harmonising approach. So what it does is it applies a model set of model act, and that's been taken up in a number of the states, although aspects of it are also appearing in different states where the model act has not been taken up. There is a copy of the model Work Health and Safety Act that's available at the Safe Work Australia website. Have a look at it, and the intention is that I think that the Model Act be taken up and enacted by the different parliaments. But the way the Act works is that there is a primary duty of care placed not on the owner or the employer, but the person that's conducting a business or an undertaking. It doesn't necessarily need to be for profit, and it can be either a business that is being operated for profit or a voluntary association. So a fairly broad duty of care to persons conducting a business or an undertaking. Likewise, worker is given a fairly broad definition. Section 7 is where you need to have a look in the Model Act, and it includes not only an employee as you'd expect, but also outworkers, apprentices, employees of a labour hire company who have been assigned to work at that particular workplace. So that's an important inclusion as well. Have a look at Section 7. Under Section 19(1), the requirement is to create a safe working environment, so far as is reasonably practical. So not put people at risk in the work environment. Provide a safe work environment, make sure that the plant and the systems are safe, make sure that there are proper systems in place for using and handling and storage of not only plant and equipment but also substances. So I think they're chemicals and the like, that there are adequate welfare facilities, and that everybody gets enough information and training as well as supervision. There is a duty imposed on a person to ensure the health and safety and that duty requires the person to eliminate risks to health and safety so far as is reasonably practicable, and if it's not reasonably practical, to entirely eliminate those risks, to at least minimise them. So have a look at Section 17 in that respect. The Act gives some guidance as to what will be required to meet this test of reasonably practicable, and you should have a look at Section 18, which contains the requirements in that respect. So taking into account a broad list of things, including these: how likely is the risk to occur? What's the degree of harm that's going to happen if the risk is not managed? What was the person's knowledge at the time? Are there available ways to minimise the risk? And what's the cost? Just with respect to those available ways to minimise the risk, we'll talk later on about the introduction in this scheme of various codes, and these are published ways to minimise particular risks. For example, working at height or working in confined spaces. Not only are the people who are directly involved in the workplace liable, but if you have a look at sections 20 through to 26, you'll see that a person who has management or control of the workplace, or the fixtures or fittings, people who design, manufacture, supply, plant substances or structures also need to be responsible for workplace safety. And as an example I can think of there, providing a dangerous chemical substance into a workplace in a container which was not suitable could be a breach of that condition. Now, again, an interesting point here. Apart from the PCBU, so the people that you could say are actually conducting the business, there are also duties which officers must embrace. So if a person conducting a business or undertaking has a duty or an obligation, then an officer, so the manager or the supervisor of the business, must exercise due diligence to ensure that the person conducting the business complies with that duty. And there are even duties on the workers themselves. They've got to take reasonable care for their own health and safety. So have a look at section 28 in that respect. Now, this is what I was talking about before. The Act also provides for regulations and standards and codes of practice. So in trying to determine whether all reasonable steps have been taken to manage workplace health and safety, section 275 says a court can consider a standard in determining what is reasonably practicable. So if there's been a published standard, say for working at height, then a court can take that into account, and if the PCBU has not complied with that standard, then chances are there's going to be a finding that they haven't taken all reasonable steps to maintain a safe workplace. Breaches of the legislation can lead to prosecution. They are treated as a criminal offence. The outcome can be an order to take remedial action, to publicise the offence. The remedial action in Queensland is sometimes called an improvement notice. So it can be a notice requiring the employer to tidy up the workplace somewhat, and the fines can be extreme. And the textbook reminds us up to $3 million for reckless conduct which leads to death or serious injury. Now, just on the subject of a safe workplace, have a look at the reference to bullying, particularly under the Fair Work Act. The textbook refers to section 789 FD1, which provides a definition for bullying in the workplace. Now, just before I get into any detail here, the reason for its inclusion is that this has become a very much a growing area for claims within the workplace. Claims that a safe workplace hasn't been provided because bullying has been allowed to go on. So what is bullying? Repeated and unreasonable behaviour directed towards a worker that creates a risk to health and safety. Now, under the Fair Work Act, it must happen while the worker is at work. Under the Act 789 FF1, the Commission can make any orders it considers appropriate to prevent further bullying other than the payment of money. So there has to be, for the Fair Work Commission to be involved in a bullying action, a couple of things need to apply. One, it needs to happen at work, so it's got to be a work-related thing. The person can't have left work and then seek assistance from the Fair Work Commission because the relationship's over. But if they wanted, if a worker wanted the relationship to continue, but they simply wanted the behaviour to stop, this would be the remedy for them. To make any order it considers appropriate to prevent further bullying other than the payment of money. Alright, now workers' compensation, a whole area of law on its own. The textbook lists the various legislation that you'll need to be familiar with, and here it is again. So have a look at the legislation in your particular state. You'll probably note that it's going to be fairly hefty, hence my comment that it's a whole area on its own. It's very much a legislative scheme, and it's probably worth confirming right at the outset that so far as the payment of medical expenses and income to a worker while they're off work because of a work-related injury, it's a no-fault scheme. So all you need is that connection with work. It may be a private or a government insurer these days, so some large workplaces have been given permission to self-insure. But the point is, it's a legislative scheme, it's an insurance scheme, all workers are covered, and there is some deeming to include labour hire workers who are working at the particular workplace, volunteers. But it's got to be an injury or an illness which arises out of or in the course of employment. And I say in the course of because journey claims are included. So a person who's travelling to and from work and is injured may also be able to make a claim. But it's very much about getting the worker back on track. So it's about the payment of medical expenses and some income protection. Now, probably more notoriously for many of you, you'll see firms advertising that they will take on common law claims. So once the statutory claim's been accepted and the worker has had a work-related injury and they have received some workers' compensation for their trouble, they might have had their medical bills paid, probably had their wages paid for some months. It is possible, if they hit certain thresholds, for them to make a common law claim, but they have to do it within the scope of the legislation. So there is a general duty on employers to take reasonable care of their workers. There is a foreseeability test before a worker could make such a common law claim, and the courts do take into account issues around contributory negligence. But the big issue is that from state to state, these schemes are sometimes capped or limited, and you'll hear about caps, for example, where a person must suffer a permanent disability of, say, not less than 5% or 10%, something of that nature. So they've been assessed that they do have an injury, and it's expressed at a percentage level, or and that gives them an entitlement to make a claim. All right, well, as I said, so just some very brief comments from my perspective around Chapter 15, because it's such a large area, and it's really just to give you a heads up about these potential issues within the workplace.